Hi friends, I am Advocate Sandip Sonawane welcomes you at my YouTube channel Advocate Guru. We are talking about as leading cases on domestic violence, that is protection of women from domestic violence, we shortly call as DV. First is doctrine of continuing domestic violence. Continuing domestic violence is related to economic abuse. In case of economic abuse, it is not necessary for the court to consider whether the domestic violence is committed prior to coming into force of the act. Saraswati versus Babu 2014 3 SCC 712. Second one is denial of maintenance under section 125 Criminal Procedure Code 1973 vis section 20 of the Domestic Violence Act. Act or omission under section 3 defining domestic violence is a broad enough to include all aggrieved person, including a not legally wedded wife and those not entitled to maintenance under section 125 of the Criminal Procedure Code. Case is Lalita Topo versus State of Jharkhand 2019 13 SCC 796. Number 3 is quashing permissible. Though section 29 deals with the provision of appeal under the Act, quashing proceeding under section 482 of the Criminal Procedure Code is permissible if no case of domestic violence is made out. Ashish Dikshit versus State of Uttar Pradesh 2013 4 SCC 176. Number 4 is retention of sridhan as continuing offence. Retention of sridhan is a continuing offence. Wife is entitled to put forth her claim under section 4 of the Domestic Violence Act anytime. The concept of continuing offence gets attracted from the date of deprivation of sridhan. Hence, application is not barred by limitation. Case is Krishna Bhattacharya ji versus Sarthi Chaudhary 2016 2 SCC page number is 705. Number 5 is right to marriage a choice. Habeas corpus petition was filed by father to produce daughter in court. When Detenu when Detenu appeared, it was found that she was major, having the age of 19, and she claimed that she is living with appellant after marrying in temple. Held that right to marry or have live in relationship with person is a choice of aggrieved person. Case law is Nandakumar versus State of Kerala 2018 16 SCC 602. Friends, on number 6, that is limitation. Limitation prescribed under section 468 of the Criminal Procedure Code 1973 held applicable to the complaint under section 12. A conclusive view on this issue does not seem to have been expressed, probably since complaint under section 12 was found to be not maintainable on other grounds. Case is Indrajit Grewal versus State of Punjab 2011 12 SCC 588. On number 7, the word adult male person unconstitutional. The definition of respondent under section 2Q of the DV Act, meaning adult male person, is struck down as violative to Article 14 of the Indian Constitution as it was a gender bias provision. After declaring Section 2Q as unconstitutional, remaining section has been rendered ottois, so it stands delected. Case laws is Hiralal Harsora vs. Kusum 2016-10 SCC 165. Number 8 is Section 27 and temporary residence. Where an aggrieved person resides at any place for a temporary period of time, application filed by her against the respondent at such place is maintainable. Case law is Shyamlal Devda vs. Parimala 2020 SCC online SC 65. On number 9 is friends, divorced wife as an aggrieved person. Aggrieved person includes divorced wife. An application filed by her under Section 12 is maintainable. Domestic violence is committed by respondent. Subsequent decree of divorce will not absolve the liability of respondent under Section 20 of the Domestic Violence Act 2005. Case is Juveria Abdul Patni vs. Atiq Iqbal in the year 2014, 10 SCC 736. Number 10 is female relative of the husband. Relatives of the husband includes even female relatives. Legislature never intended to exclude female relative of the his and from the purview of the respondent. Case is Sandhya Wankhede vs. Manoj Wankhede in the year 2011, 3 SCC 650. Number 11. Act is retrospective in nature. The Act of 2005 is retrospective in nature. Wife residing separately at the age of 63, wife entitled to file complaint under Section 12 of the Act. Case is V.D. Banot vs. Sarita Banot in the year 2012, 3 SCC 183. Also, the complaint was made after 15 years when couples started living separately, which was much before the enforcement of the Act held the complaint is maintainable. In the case Shalini vs. Kishore, AIR 2015, SC 2006-05. Number 12. Requirement of DIR. Report of Protection Officer under Section 12 of the Domestic Violence DV Act is not a mandatory rule of law. If no report is filed by protection officer, then it does not affect the merit of the case and there is no abuse of process of law, which is seen in case Manoj Changani vs. Prema Changani in the year 2012, SCC Online Bombay 38. Number 13 is friends, considerations while granting maintenance. While granting maintenance, the court has to strike a balance between earning capacity of the husband and need of wife and children. Material placed before the court be considered. Court cannot act on its own assumption and surmise, which is seen in case Prakash Singhi vs. Amrapali in the year 2018, SCC Online Bombay 1197. Number 14 is Act is of civil nature. The Act of 2005 is predominantly of a civil nature. It assumes character of criminality only when there is a breach of protection under Section 31 by respondent and there is refusal to carry out the duties by protection officer under Section 33 of the Act. which is seen in case Nandakishore Vyavhare versus Mangla 2018 online Bombay 923 full bench. Next point is maintenance from relative. Brother-in-law can be held liable to maintenance to pay the widow and child of his brother from earning of joint family property. In the case Ajay Kumar versus Lata, AIR 2019 SC 2600. Next point is, friends, multiple maintenance. Maintenance granted under section 125 of the Criminal Procedure Code 1973 and also under Hindu Marriage Act respectively. Residence order also passed under the Act 2005 held aggrieved person entitled to get relief provided though granted under any other law, which is seen in Kiran Patidar versus Sanjay Patidar, AIR 2018 SC Supra 960. Next point is, friends, domestic relationship. It is necessary that the parties had lived in domestic relationship in a shared household. If parties never live in domestic relationship, no case of domestic violence is made out, which is seen in case Manmohan versus Neelam, AIR 2070 SC 3345. And absence of domestic relationship proceeding under Domestic Violence Act DV Act is not maintainable, which is seen in case Jayesh Khernar versus State of Maharashtra 2009 SCC Online Bombay 1369. Next point is, print amendments permissible. The court dealing with the application filed under section 12 of the Act has a power to allow amendments in relation to subsequent event or with a view to avoid multiplicity of litigation. There is amendment permissible seen in case Kunna Pareddy versus Kunna Pareddy, AI 2016 SC 2519. Next point is relationship in the nature of marriage. To claim reliefs under the Act, relationship in the nature of marriage should fulfill four requirements. They must be of legal age to marry. Second one is they must be qualified to enter into legal marriage, including being unmarried. Third one is society must treat them as a spouse. And last one is they must resided in a shared household for a significant period of time. This doctrine is in Velusamy versus Pachamiyamal AI 2011 SC 479. Next doctrine is House of In-laws. Aggrieved wife is not entitled to get right of residence in the house of in-laws. Mother-in-law's house does not become sharehold only because applicant wife had shared that house with her husband earlier. S.B. Batra versus Taruna Batra, AR 2007 SC 1118. DV Act and RTI Act. Respondent husband sought information about provident fund and salary of wife by filing application under RTI Act, Right to Information Act. Information was sought for the purpose of litigation. Held husband cannot be termed as a third party or stranger. No question of invasion of privacy. Husband entitled to get information. This scene is case of Central Public Information Officer versus Central Information Commissioner, AIR 2018 Bombay 26. Execution of maintenance order. Magistrate can adopt the proceeding as laid down in section 25(3) of the Criminal Procedure Code 1973 in view of section 28 of subsection 1 of Domestic Violence Act 2005. This doctrine is in Sachin Bodle case versus Sushma Bodle 2014 SCC Online Bombay 592. Magistrate can issue NBW for recovery of maintenance in view of section 28 subsection 2 of Protection of Women from Domestic Violence, that is in short DV Act 2005, which is seen in case Sagar Shendge versus Naina 2013 2 Crimes 2018 Bombay High Court. Friends, this video is relating to leading cases of domestic violence cases. If you like this video, please share, like and comment also. Thank you. Jai Hind, Jai Maharashtra.